Hello, hello, everybody. Hello. Good evening. Happy Thursday. Or, hey, look, we're almost at Friday. Almost, not quite there yet. Yes. Well, welcome in, welcome in. I have a filing that was done today by the administration, and I thought, well, let's just look at that, such that it is here. Let me see. Let me just check my dates on here. I really file these in a very odd way, in my humble opinion. Let's just flip here. Because I've noticed with these filings from the administration, actually for just Mr. Orange's legal team, they've always been doing this. They've done this in Florida, Georgia, New York, all of the places in DC, of course. What they do is they will make a filing, but then they will add buckets of extra court stuff. So here we go. Here's the end, right? And then they keep going because they will just attach all of these other orders and such. So this short 29 pager is now 168 pages. Now you want to do that to some degree, but on the other hand, it really kind of bogs down the whole process and it makes it look good, but it's just not necessary. So there we go. Are they charging by the page? It's a great question. I wonder. Hello, Thomas. Welcome in. I do wonder. That's such a good point. All right. So we've had some movement here. Well, such that it is. We have a filing that was done today, although I did not print out 168 pages. So I don't have the final page in here, but it was filed today, and it has to do with a case that I have gone through actually on the live. So I thought, well, that's interesting, right? Hello, Nancy. Tina, hello, welcome. Welcome. So this was the California case where we had First Amendment issues. We have a habeas corpus request in here. So this is the original lawsuit, so we can kind of just take a peek here in here to see what's going on. So I will go ahead and read the complaint, just the first couple pages here, so you just know what's going on. And then we have this request to the U.S. Supreme Court. So, I mean, that's a lot. Yes, good evening to you as well. Welcome. Let me get my sticky notes set here. All right, so we have, this is, I guess because they're flipped here. We'll do Noem versus Perdomo. Again, I did do a live a little while back talking about this case. We have, this is where the cubes were so aggressive during in Los Angeles. So that's kind of the the structure of this has to come from that. So we have here, I'm just going to put the regular file number in here, everyone. You should be able to click through to the document that I'm going to be going through tonight if you want to. So but I'll just put the original file number here. All right, and originally this was filed July 2nd here. So July 2nd. Oh no, not getting I tell you, there's something kind of hinky going on. Hello, Autumn. Something hinky going on on the talk, I've noticed when it comes to. I'm like, what? Where'd everybody go? I didn't know. I'm looking for everyone. I think we've lost a few here, but we'll get there. So this is our SCOUTUS request is what I will be going through. Request to stay. A lower court's order here. All right, so hinky business. You got it, Steffi. You got it. Hello, Anita. Welcome in. You know, I feel like I'm so glad to be back, but for some reason, like everything seems to not be working properly. Does everybody get that feeling once in a while? Like, what? That could have gone better. So that's kind of been my day so far, but that's all right. We'll just keep on, we'll keep on trucking, do the best we can, right? Oh my gosh! Hello, June Marie. Revenge of really interesting. Let Carbon do it. Oh, that's very interesting. Yeah. Anyone else? Yeah, Duchess. You hear what I'm saying, right? Yes. 2 nights in a row. I know. I've got to catch up. We've got to make up. Got to make up some time in the air, everybody, because I have a stack of cases and court papers and such that I need to do lives on. I guess need isn't the right word, that I would love to do lives on. So I got to start getting myself together here so we can do these. Take some time away. Oh, absolutely. Absolutely. You have to. You have to, everyone. There's just so much and so much multiple ways that there's too much going on. So you've got to take some good breaks and spend some time with your family, you know, or not. You know, we had a week vacation in Colorado, and then when we got home, the hubs was like, all right, I'm going to go away for a while. I just can't, I don't want to be around any of you for a while. And I tell you what, he was talking to an empty room because we were already gone. We had gone to our separate places. So we just need our space sometimes. We need to be alone. Oh my gosh. But family's wonderful. We do love that. But it's also good to have a break, right? All right. So that's my story. So here we go, everyone. I just want to read just a couple pages here into the complaint to give you context for the filing that came down here from Mr. Orange. You're going to post videos on the trip? I might. I'm starting to. I've got to get some things sorted out over on the tube, but a lot of the videos I made, the sound isn't very good, so that's kind of like my bad, but we'll get it sorted. It'll be fun. Needing a vacation from, well, exactly. That's what I'm saying, Danny. That's what I'm saying. I'm like, look, this has been great. This has been fun, you know, but I'm ready to go somewhere else. You saw the closet docket. Oh my gosh, everybody, the closet docket's getting out of control. It's just getting out of control. And I had to move the executive orders to a different room because it was too much. It was too much. So now I have all of my closet's almost completely covered. And then I have all of these foam boards with all of the other ones. I'm like, what's happening? There's just so many. Oh my gosh. With taxes. Oh yeah. Hello, Thomas. Hello. Hi, Willie B. If I didn't say hello already. Or here's your second. Hi. Hope everyone's doing well. Right. So I'm hoping to do actually a live on the closet docket, doing a review. I had done that before a couple of times and people found that interesting. So I'll probably do a full live on that very soon. Hopefully. Hello, Dolores. Hello. And Mama. Hello. Penny Sue. Oh, I love those doubled names. I just love it. So for tonight, everyone, it's been fun, but not real fun. I know. It's been like, yeah, it's a have to, not a want to. Here we go. So the United States District Court for the Central District of California, we have this group of people and organizations that filed a lawsuit against the government. So let's take a peek here. We've got Perdomo as the first person, then Osorto and Villegas, I'm not saying that right, Molina, Hernandez, Viramontes, Gavidia, Los Angeles Workers Center Network, United Farm Workers Coalition for Humane Immigrant Rights, and Immigrant Defenders Law Center. So we've got a lot of people here as the plaintiffs. Hello, Casey. So a lot of people in there. So we've got a lot of people here as the plaintiffs. Hello, Casey. So a lot of people in there. And it's a class situation, I believe, at this point. So they are suing then all the big names, right? So we've got Noem, Lyons in here, Scott, Banks, Cash Patel. We always like that when Patel is included because I just think that's for fun. In his official capacity, all right. And then we have Bondi, Santa Cruz Jr. here, Wang, Bavino, Stolniker, and Davis, and Asali. Asali. Anyway, so we've got a mixed bag here. We've got a mixed bag of federal and state people. And that's because the state's kind of screwing up too. And it's a bit like the alligator Alcatraz situation, which I don't like to call it that, but that seems to be what everybody knows, where we have, again, this mix between federal and state law enforcement in here. So yes, hello, Real Life Works. I hope you're doing well. Yes, so here are my nails today, everyone. Forgive me. I have, it's been one of those days. So I lost one somewhere. So I had to put another one on. That's all right. It's all right. It's just different. It's okay to be different. That's what I'm going to tell myself. All right. So let's get into this. I will, again, just be reading through the first page. So we've got context for the Supreme Court petition that they put in today. Right, exactly. All right, introduction. This lawsuit seeks to enjoin defendants' ongoing pattern and practice of flouting the Constitution and federal law in connection with ongoing immigration raids in the Los Angeles area. All right, so this is the plaintiff's complaint. All right, keep that in mind. So all of the people we were just talking about are the ones filing, and the defendants are, of course, the government. So there you are. Since early June, this district has been under siege. Masked federal agents, sometimes dressed in military-style clothing, have conducted indiscriminate immigration operations, flooding street corners, bus stops, parking lots, agricultural sites, day labor corners, and other places, setting up checkpoints and entering businesses, interrogating residents as they are working, looking for work, or otherwise trying to go about their daily lives, and taking people away. Right? The raids in this district follow a common systematic pattern. Individuals with brown skin are approached or pulled aside by unidentified federal agents, suddenly with a show of force, and made to answer questions about who they are and where they are from. If they hesitate, attempt to leave, or do not answer the question to the satisfaction of the agents, they're detained, sometimes tackled, handcuffed, and or taken into custody. So again, that's worth noting. In these interactions, agents typically have no prior information about the individual and no warrant of any kind. If agents make an arrest contrary to federal law, they do not make any determination of whether a person poses a risk of flight before a warrant can be obtained. So that's another piece too to remember, everyone. We actually have some requirements in order for someone to be taken into detention. And one of those is, do we have a flight risk going on here? Also, contrary to federal law, the agents do not identify themselves or explain why the individual is being arrested. That's a pretty major violation here when we're talking about the Fourth Amendment and, a lot of precedent. Further, apparently to accommodate the sharp rise in arrests, the government has resorted to keeping individuals in what's supposed to be a short-term processing center and cube basement holding area in downtown Los Angeles, known as B18. Often for days in these dungeon-like facilities, conditions are deplorable and unconstitutional. The government has also unlawfully deprived those arrested of access to counsel. And we want to remember that we're looking at counsel under the Fifth Amendment Due Process Clause, as opposed to criminal counsel under the Sixth Amendment. Under such conditions, some of those arrested are pressured into accepting voluntary departure. The government is aware that its Actions are unconstitutional and contrary to officers' training, but deliberately persist because this system allows it to coerce removals, avoid public accountability, and ultimately, given the limited bed space at long-term detention facilities in the area, keep arrest numbers high. Federal immigration enforcement is constrained by law, but since the federal government began its mass immigration enforcement operations in this district on June 6th of 2025, all of those legal requirements have given way to one overriding consideration, quote, numbers, pure numbers, quantity over quality, end quote, and our footnotes are giving us our citation here. In late May, the White House and Department of Homeland Security imposed a quota of 3,000 immigration-related arrests per day, with consequences for not hitting arrest targets. In order to reach this target, White House Deputy Chief of Staff Stephen Miller directed high-level officials to change their approach to stops and arrests in the field, which of course we have case precedent setting out a stop and an arrest and what can be done. Of course, the most famous would be Terry v. Ohio. Here, there we go. Just remember that. Agents and officers, according to him, should no longer conduct targeted operations based on investigations. Instead, they should just go out there and arrest unauthorized non-citizens by rounding up people in public spaces like Home Depot and 7-Eleven convenience stores. This comprehensive scheme has been guised as a crackdown on the worst of the worst, but the preponderance of individuals stopped and arrested in the raids have not been targeted in any meaningful sense of the word, except on the basis of their skin color and occupation. Those who have borne the brunt of defendants' heavy-handed pattern of unlawful conduct include day laborers, car wash workers, farm workers, street vendors, service workers, caregivers, and others who form the lifeblood of communities across Southern California. Over 1,000 residents in the district have already been impacted, including a shocking, though hardly surprising, number of U.S. citizens and individuals lawfully present in the country. Oh, you're so welcome. You're very, very welcome, Carrie. Thanks for coming by. I appreciate you. Number 8, this case challenges the government's use of unlawful tactics to achieve its intended arrest numbers in the district. Plaintiffs include 5 individuals and 3 membership organizations: the Los Angeles Workers Center Network, United Farm Workers, and the Coalition for Humane Immigrant Rights, together with the Stop Arrest plaintiffs. Who on behalf of themselves and others similarly situated bring claims challenging defendants' unlawful stop and arrest practices. Plaintiffs also include Immigrant Defenders Law Center, who alongside the Coalition for Humane Immigrant Rights seek to challenge defendants' denial of access to counsel and illegal conditions of confinement at B18. Despite the fear and risks associated with speaking publicly, they are taking courageous action to enforce the rule of law. They seek declaratory and injunctive relief, as well as relief under the Administrative Procedure Act. All right, so this is the plaintiff's complaint. Now, we did have the judge in this case, and I have read her order. It's actually incredibly well written. Did come in and put some restrictions in place. She said, look, you guys need to get yourself sorted out, but until the litigation moves further down the road, we'll put an injunction into place just to keep things, constitutional. All right. So that is what they are appealing right here. This is from the administration, and they are asking the Supreme Court. They're just like filing stuff for the Supreme Court, and they're saying we would like to have a stay. And this stay would be of the lower court's injunction, stopping them from doing this. All right. So that's what they're asking for in their request here. So let's take a look. I don't particularly enjoy going through these filings because they're just wrong. That's why it bothers me to be reading stuff that is incorrect. But here we go. So this was filed by the Solicitor General also known as this fella, who was representing Mr. Orange during the New York trial and multiple other cases as well. So this fella right here, again, the Stormy Daniels situation involved him. Learning a lot on, oh yeah, there's tons of different ways of writing. I'm not a big fan of Mr. Sawyer's, which is probably just some kind of a free intern that's following him around. So here's a table of contents. We have a background, proceedings below, so quick overview of that. Argument here, the government is likely to succeed on the merits. So again, we're using what we call the winter test here. The winter test sets out, I think it's four or five requirements that you have to meet in order to rise to the level of getting a preliminary injunction. Because preliminary injunctions should be and used to be very rare. It was a very rare occurrence, but because of how things are being done here, where they're putting in emergency, like immediate, removal to other countries and stuff, the preliminary injunction situation has really escalated. Yeah, we have a lot. We have a lot of emergencies allegedly going on here. All right, so again, winter factors here. All right, and then the respondents lack standing to seek injunctive relief, restricting investigative stops for immigration enforcement. So they're saying they don't have any standing. Standing means that you actually have the ability to bring a lawsuit. So if you've got standing, it means you are connected enough to what happened that you're in the, what do we call it? The zone of whatevers. The zone of danger. I can't remember. But if you are harmed, that's an H. That's not working out for me, everyone. It's been a day. What's important here, all right? Are you connected close enough to what happened in order to have standing? It can't be, something's going to happen, and it can't be, well, it already happened, but, we're upset about it kind of a situation. So you've got to be in proper standing in order for the case to go forward. What? I'm just going to go crazy if I don't remember. Hold on a second, everybody. I've got to pull that second word up. Oh my gosh, my OCD's like, what's that word I'm looking for? Zone of interest? No, that's not it. Oh dear. Lawsuits. Yeah, I guess it is a zone of danger. Oh, good for me. Wait, proximity? No, that's not right either. Zone of danger. Well, hold on. Yeah, it is danger. Good for me. Oh man, I need to trust myself more. All right, it's the zone of danger. Oh my gosh. Yes, heard that word. We're going, oh, good. All right, so what I was trying to do here is, give you a little bit of an insight. We call this zone of danger, which I had listed, but then took it back because I didn't have the confidence. And if you want to go super old school, this comes from the Palsgraf case. And I'm going to spell it wrong. It's Palsgraf, whatever. Incorrectly spelled. This is the case that set out the zone of danger. Zone of danger, meaning you have to be close enough to the harm in order to bring a lawsuit. All right, so that's my standing lecture right there. Hello, girl and her brushes. Oh, the mountains were beautiful. Oh, they were gorgeous. All right, so Palsgraf, zone of danger. They're saying they don't have standing for this injunctive relief, all right? Number 2, district court grossly misapplied the Fourth Amendment. Now, the Fifth Amendment is, right, freedom from unreasonable search and seizures, and is the most litigated of all of the amendments. Thank you very much, Pauls and Graf. Did I do that? Am I close? Oh, maybe this is an A, and maybe only one F. All right. You know what I'm saying, right? This is the train station case. No, I shouldn't know this, but I do. These are one of the things that's in my brain instead of what day of the week it is. I'll switch. All right. Fourth Amendment, the most litigated of all amendments. So the Central District wide injunction vastly exceeds the district court's equitable powers. This whole question on equitable powers is another legal concept that we bring up in order to show who can do what with what kind of law. Right. Thank you. Real life works. Yes. I think there's actually a really interesting little animation on the Paulsgraf case, in case any of you cared, which I will be watching that later, but I'm not sure about anyone else. Here's B. The remaining state factors support the relief. So this court would likely grant cert, meaning we would likely be in front of SCOUTUS. The district court's order inflicts irreparable harm on the government. This irreparable harm element is one of those things that SCOUTUS is really split on, depending on if you're more conservative or more liberal. Irreparable harm is what Justice Jackson had said was something to really keep our eye on here on some of these cases. And the balance of equities weighs in the government's favor. And we also have harm to the public. So we got to kind of put those in there as well. An administrative stay is warranted. So they're closing it up by saying we should have a stay because the winter factors aren't fulfilled. All right, so that's really what this means overall. So let's dive in. We have parties to the proceeding, and I did already go through that. So let's skip ahead. Related proceedings, we have July 11th. Temporary restraining order was put into place, and then August 1st, denying a motion for a stay. So the court already said we're not going to give you a stay. So because of that, they are going to the U.S. Supreme Court. Oh, thank you, Kristen. Hello. Yes, don't forget the boops, everybody. Like, you remember the boop days? For those that have been here for a while, I miss the boop days. Those were some of the best days. For sure. All right, here we go. So we have Noem, again, because they're appealing against the plaintiff here. And they have submitted an application to stay the order issued by the United States District Court for the Central District of California and request for an immediate administrative stay. So they want the lower court's order to be stopped, all right? That's what they're asking the Supreme Court about. Pursuant to Rule 23 of the rules of this court, so that would be SCOUTUS, and of the All Writs Act 28 U.S. Code Section 1651, the Solicitor General, on behalf of applicants, Noem, and Homeland Security et al. Respectfully files this application to stay the July 11th order issued by the United States District Court of the Central District of California. In addition, the Solicitor General respectfully requests an administrative stay of the District Court's order here. This case involves a district court injunction that threatens to upend immigration officials' ability to enforce the immigration laws in the Central District of California by hanging the prospect of contempt over every investigative stop of suspected illegal aliens. I'm going to stop here for a minute. Nowhere in her order did she say you can't go and detain people. What she put in her order was that you have to still have a reasonable suspicion. You still have to follow the constitutional rules if you're going to detain somebody. So that's it. If you've got reasonable suspicion, there you go forward. Be on your way to do what you need to do. So she was not halting anything. She was saying you need to be in compliance with the Fourth Amendment. Not only is the Central District of the nation's most populous district overall, at best estimate, it harbored some 2 million illegal aliens out of its total population of nearly 20 million people, making it by far the largest destination for illegal aliens. Given the administration's commitment to enforcing the nation's immigration laws, under which, but only immigration, not constitutional laws. Let's just make that note here. But not constitutional law. Oh my goodness, everyone. Someone needs to go back and read that. Under which illegal aliens are subject to investigative stops and detention to facilitate removal. It should be no surprise that the Los Angeles area is a top enforcement priority. When immigration enforcement stops involve briefly detaining a suspect illegal alien, they must comply with the Fourth Amendment's reasonable suspicion requirement, a low bar that's considerably less than a preponderance, which is the level in civil court. Citing case law. Like most Fourth Amendment tests, the context-specific inquiry requires considering the totality of the circumstances. And here, those circumstances necessarily include that illegal presence is widespread in the district. This is where they are really harming themselves here. Well, I mean, if we were in the reality of how it's supposed to be, right? So they're saying just by being in the country, that's reasonable suspicion. And the only way you're going to know that, right, if you just look at someone and you don't know who they are. You look at someone and you're like, okay, you're here illegally. What factors are going through your brain that make you think that the person in front of you could be here illegally? That's where we're getting into our targeted issues here. And civil rights violations is just looking at appearance. That's going to be an issue. Well, right. They're brown. I mean, oh my goodness gracious. Exactly. So they're saying just because they're brown, we automatically now have this kind of reasonable suspicion. So illegal presence is widespread in the Central District, where 1 in every 10 people is an illegal alien. I don't know if that's correct or not, that citation, and that statement, there is no citation. So we don't have any facts to back that up. That many locations unlawfully employ illegal aliens and are known to hire them on a day-to-day basis. That certain types of job, like day labor, landscaping, and construction, are most attractive to illegal aliens because they often do not require paperwork. All right, so just the presence is going to be one of the factors he's saying. And the type of job you have is going to be another factor. Right, anyone is fair target. Exactly, and that's exactly right, Willie B. They're just saying, well, look, just because we're standing here, we know that 1 in 10 of you does not have proper paperwork. So we're going to arrest all 10 and see which one it is. That's not how that works. All right. So, and then depending on what their job is, are most attractive. Right. They do not require paperwork. That the vast majority of illegal aliens in the district come from Mexico or Central America and may only speak Spanish. So this is number 3. How's your English? How is your English? Are you speaking only Spanish? Or like a mix, like Spanglish? That was my grandmother was a Spanglish person. And I loved it. I just didn't understand about 50% of what she's saying. I'm like, Grandma, come on. Help me out here. And when she did, she just was talking very slow. I'm like, just because you're slowing it down doesn't mean I understand the Spanish. Oh my gosh. I'm sorry. Sorry about that. There we go. Side trip there for a minute. Oh, thank you so much, Nani. I appreciate that. All right, here we go. Needless to say, no one thinks that speaking Spanish or working in construction always creates reasonable suspicion. That's going to be our bologna sandwich zone here. Nor does anyone suggest that those are the only factors federal agents ever consider. But in many situations, such factors alone or in combination can heighten the likelihood that someone is unlawfully present in the United States, above and beyond the 1 in 10 baseline odds in the district. U.S. Immigration Customs Enforcement agents are entitled to rely on these factors when ramping up enforcement of immigration laws in the district. So again, we are in a situation where we're saying, first of all, what's your appearance? Second of all, what kind of a job do you have? Third of all, do you speak Spanish? Those are the factors here. And he's saying, well, maybe not just that, but whatever. So that's pretty... I'm Spanglish. I love the Spanglish, right? Oh my gosh. It's in my opinion, it's another language, in my humble opinion. And yeah, it's interesting. I probably should have learned more so my poor grandma wouldn't be so frustrated with me. I digress. The district court's injunction now significantly interferes with federal enforcement efforts across the region. that is larger and more populous than most countries, and that has become a major epicenter of the immigration crisis. Respondents, a handful of individuals who alleged they were previously stopped without reasonable suspicion, and various organizations purporting to represent some indefinite number of unidentified aliens, alleged the federal agents have an unlawful pattern or practice of considering some combination of 4 factors, apparently race or ethnicity, speaking Spanish, right, or accented English, presence at a location where illegal aliens are known to gather, and working or appearing to work in a particular type of job. Right, so these are all the things we just went through. And he's saying, well, just because we're using these factors, oh my goodness. The court then indefinitely and categorically enjoined federal agents from ever treating those 4 factors alone or collectively as sufficient to constitute reasonable suspicion of illegal presence as to any of the Central District's 20 million residents. The District Court and the Ninth Circuit both refused to stay that order. Now, Cube agents, under the threat of contempt, cannot detain anyone in the district solely based on those factors. Yep, not even after encountering someone who speaks only Spanish and works as a day laborer at a work site that has been cited 30 times for hiring illegal aliens as day laborers. Oh my gosh, that's a smart-ass comment. Wow, Sawyer, be professional. That seems impossible here. So he's basically saying that you can't, they just don't have permission to detain anybody, which isn't true. And then look at the language he's using. I mean, that's just incredibly telling, isn't it? Not even after encountering someone who speaks only Spanish, right? Come on. And works as a day laborer, again, at a work site that's been cited 30 times for hiring illegal aliens. I guess it's pretty rough. Yeah, VC, exactly. Exactly. So, yikes. That sweeping injunction defies a host of this court's precedents. Start with Article 3 standing precedents. Even assuming arguendo that individual respondents or members of the organizational respondents were stopped previously without reasonable suspicion, a point the government contests, this court has long held that allegations of past unlawful interactions with law enforcement do not show a sufficient risk of future unlawful interactions. Just because respondents were previously detained does not mean that they, out of the Central District's 20 million people, will be detained again, let alone detained based solely on the 4 factors. The lower courts instead found standing based on a supposed pattern or practice of unlawful stops, which, to be clear, does not exist, and speculation about future harm, but neither supplies a sufficient imminent concrete risk that respondents will be unlawfully stopped in the future. And this court has rejected the Court of Appeals theory of standing based off of mere assessment of statistical probabilities. Citing case law here. Right, exactly. Oh, we can't discriminate, boo-hoo. Come on. Meanwhile, on the merits, the injunction defies black-letter Fourth Amendment law, imposing a straitjacket on law enforcement efforts that is inimical to the context and case-specific totality of the circumstances inquiry that this court's precedents demand. The lower courts wrongly combined the reasonable suspicion inquiry by holding that no combination of the 4 factors can ever constitute reasonable suspicion, no matter how those factors present in a given stop, because the lower courts viewed those factors as too generalized and broadly applicable across the population. That framework narrows reasonable suspicion through the sort of overlay of a categorical scheme on the general reasonableness analysis that this court has consistently rejected, citing a couple cases here. The lower court's approach also ignores the relevant factual context. In a district where about 10% of all residents are illegal aliens, reasonable suspicion to stop suspected illegal aliens will necessarily encompass a reasonably broad profile. The result is a self-contradictory injunction. The lower courts found, standing based on the supposedly concrete likelihood that respondents out of millions might be stopped on impermissible grounds, yet refused to find reasonable suspicion because these grounds describe far too many people. All right, so, right. Yeah, right. Here we go. We're going to keep moving forward here. I'll come back. I have thoughts, but we'll come back. On top of all of that, by imposing a universal district-wide injunction. So if it's district-wide, is that universal? I have questions about that. Applicable to millions of people, the district court flouted this court's recent decision in CASA, prohibiting such universal injunctions. Rather than limiting relief to the named respondents, the court enjoined the government as to any detentive stops or of anyone among the 20 million inhabitants of the Central District of California, whether those stops affect residents or not. The lower courts deemed a narrower injunction unworkable. But under their logic, universal injunctions, next page here, hopefully I'm in screen well enough for everybody, would be the norm whenever law enforcement officers are alleged to have employed any practice violating the Fourth Amendment. CASA is not so easily evaded. Any one of those fatal flaws would warrant this court's review. This injunction inflicts manifest irreparable harm on the government. The injunction wrongly brands countless lawful stops as unconstitutional, thereby hampering a basic law enforcement tool while turning every single stop in the district into a potential contempt trap. What the H is that? Oh my goodness gracious. No agent can confidently enforce the law and engage in routine stops where the district court may later refuse to credit that the stop reflected additional permissible factors and instead treat virtually any stop as a contemptuous misconduct. Again, the judge is saying you need to use the stop and frisk rules. That's what you're supposed to use. So if you don't have your reasonable suspicion to stop and frisk, then you can't do that. I mean, that's just like what everybody has to do. So they're saying citizens can have reasonable suspicion, but if you're not a citizen, you can't. And we have like decades of case law stating that non-citizens do have some limited rights in the Constitution. Not all of them, because you can't vote, but some limited rights, and that definitely includes the Fourth Amendment. We even have case law specifically saying in the Fourth Amendment when it comes to people who do not have proper documentation. So this is just incorrect. There's no stop as contemptuous misconduct. What they're trying to do here is say reasonable suspicion applies to everybody, not just to citizens. Just because someone wants to check their work, they're not going to do any work. Yeah, I mean, that's also a bit, it's a bit disheartening, honestly, to think that these are, quote, law enforcement, essentially, the cubes. They're law enforcement that don't have to be trained properly, but they come in and they're like, well, why can't we just use race, their job, and location? Why can't we just use those? If we just use those, then we'll be able to take care of 10% of your population here. This is no, VC. Oops, here we go. Sorry, yikes. Nope, this is a complaint written. My goodness. This is a complaint written and applied to the defendants are petitioning the Supreme Court to stay the lower court's protective orders. Thanks, Tommy. Case law is opinion, and you can argue your opinion any which way you want. Well, I don't know about that. I'm not sure. You certainly, no matter what you're doing in the legal field, you should be able to argue both ways, not just opinions that we call them. All right, and that threat, unlike respondents' fears of future stops, is hardly speculative. The lower courts have already made clear that some obviously permissible additional factors, like law enforcement officers' past experience, are not additional factors at all, but fold into the 4 factors those courts consider insufficient. And the district court has already ordered the government to show cause. why it should not also be required to develop new policies, compel agents to undergo training, and even share records of every stop with plaintiffs' counsel going forward. So, oh my gosh, oh no, VC, no, we can't have that. Right, I think the training would be great, right? I mean, shouldn't anybody with the authority to detain someone have some kind of training? I mean, I would be for that. When lower courts have tried to stymie other areas of immigration enforcement with unlawful blunderbuss injunctions, this court has not hesitated to stay those orders. And we've got how many of these cases going on? Well, there's one from 2019. The others are cases going on right now. This injunction warrants the same treatment. Absent this court's intervention, a single district judge will micromanage immigration. Hey, that's my word I've been using. He just took my word. Micromanage immigration enforcement in the Central District by injunction at the expense of the executive branch, enforcement priorities, and the separation of powers. So that's all not true. This court should end this attempted judicial usurpation of immigration enforcement functions and issue a stay forthwith. Again, reminding everyone that the court is just saying you have to use the same standard as the standard you use for citizens because of the Fourth Amendment. All right. That's right. Give me my word back. Give me my word back. All right, here we go. This is the background. Again, this is the background from the perspective of the government. And I think that it's incredibly helpful to see what they're saying, not necessarily so we can come to some agreement, because at this point, forget about it. But I think it's important to know what the other side is arguing so you can meet that argument with good factual information. Background. Here we go. Just a minute. Have some tea here. All right, background. Based on the latest census and Office of Homeland Security statistics data, the government estimates that at least 15 million illegal aliens and likely several million more are unlawfully present in the United States. These numbers that they're using, my goodness. So they're saying here, immigration studies, foreign-born number, and share of U.S. population at all-time highs in January here. So they're citing the different resources that they're using in order to make that determination. I think that's questionable. Very light on citations, VC. Absolutely. It's interesting. Millions of them crossed into the country illegally within the last 40 years. From 2021 to 2024, federal agents encountered some 9 million illegal aliens along the border. Many others illegally entered after evading detection entirely. And there's a Homeland Security thing for January 16th here. By current estimates, some 12.8 million aliens entered the country illegally during the previous administration. The Immigration and Nationality Act, consistent with statutes enacted throughout the nation's history, authorizes immigration officers to search for and apprehend illegal aliens to facilitate their removal from the United States, citing case law here and statutes here. Keep on flipping. All right. In all cases where, in the opinion of the president, the public safety requires a speedy removal, he is authorized to make that removal. The INA authorizes agents to interrogate any alien or person believed to be an alien as his right to be or to remain in the United States, and arrest any alien if they have reason to believe that that alien is in the United States in violation of immigration law or regulation and is likely to escape before a warrant can be obtained for his arrest. So this escape piece, right? So the likelihood of escaping, they're acknowledging that is a factor. They're just not using it as a factor. Yeah, I agree. Well, the other thing too, everyone, that I think is absolutely overlooked is, you can't lie so many times and then expect people to believe you, right? Like you can, I don't know, what should we give Mr. Orange? We'll give him 2 dozen lies. We'll give you 2 dozen lies. And then after that, we're not necessarily going to believe the words coming out of your mouth. And the problem is his 2 dozen lies are like in 3 hours on his first day in office. So we've just got this huge trust breach, and there seems to be no way to build back that trust, because trust is a moment where you have to acknowledge that you've done something wrong. Right. So if you say, yeah, I was wrong, I'm going to do better next time. All right, now we're rebuilding trust. But if you don't, then forget about it. There's no trust. Thought they needed a warrant. They don't always need a warrant. Again, and we're kind of in this weird situation where we have like a quasi law enforcement. So quasi law enforcement's the same as a regular citizen, right? So if you're a citizen and you say, well, this person's committing an illegal act, you can do a citizen's arrest, right? So these people are trained to be like, well, they're brown, they work at Home Depot temporarily, and they speak Spanish. So I'm going to detain them. And I'm going to have a pack of bullies with me and an unventilated moving truck to put them into. Because that's just what I want to do here. Officers must have specific articulable facts suggesting the person is not legally... That's right. They should. And they don't. And the attorney here is arguing that they shouldn't have to do that. All right, next, number 1 up there, and then 2, see Nielsen pre-app here, noting statutes vesting immigration enforcement powers in the Secretary of Homeland Security, and C, authorizing immigration officers to interrogate and arrest aliens. So that's another question I have too. Like if we're going down this road that people who are not citizens, so non-citizens don't have constitutional protections, right? Due process, they don't have it, right? Or they don't have a right to be free from unreasonable searches and seizures. Now, what happened, at first you're like, well, that sucks, but so what? Because what will happen is they will be rounded up and interrogated. And who's to say they're going to follow the rules for interrogation? Right? We have actual legal rules regarding how to interrogate people. And there are lines that you cannot cross. But does that still hold true for non-citizens? We don't even know. And because we've got such a breach of trust, there's no way to know that they're using appropriate techniques to interrogate. Right? What they do if every... Well, right. Oh my gosh. And there's nowhere for anybody to go either. So, yowzers. But again, it's a slippery slope. Once you start tossing the Constitution aside and saying, this doesn't apply to you, it's a slippery slope and can easily be turned into something pretty awful, in my humble opinion. This was one of the things that I absolutely disagreed with Obama on, was the situation with that. So Guantanamo Bay situation, not good stuff. Immigration officers can exercise those powers without a warrant, and they can detain individuals for questioning consistent with the Fourth Amendment based on reasonable suspicion of illegal presence in the United States, as this court has held in this case in 1975. And Terry v. Ohio. Ooh, Terry look at that. Terry just made a moment. Terry's in the case. Yay! Reasonable suspicion requires awareness of specific articulable facts together with rational inferences from those facts that reasonably warrant suspicion that the person is an alien who may be illegally in the country. The reasonable suspicion inquiry turns on the totality of the particular circumstances, which it's all true. Right, all true. Such investigative stops have been a critical component of the day-to-day federal immigration enforcement efforts for decades across administrations. And this is another thing too I'm seeing this administration doing all the time, everyone, is they're saying, well, everybody else did it before. And my answer to that is, well, they are also doing stuff that's illegal, right? Like they should be arrested. They should be held accountable. Like, well, that's how it's always been. Well, how it's always been has been a violation of the U.S. Constitution. And no one's been called out. But this one we're calling out because it's time, That's something to think about as well. Federal regulations implementing the INA expressly contemplate such stops and codify the reasonable suspicion requirement. Quote, if the immigration officer has a reasonable suspicion based on specific articulable facts that the person being questioned is or is attempting to be engaged in an offense against the United States. That's kind of interesting. Or is an alien illegally in the U.S., the immigration officer may briefly detain that person for questioning. Right. Again, you have to have reasonable, articulable facts, not just, well, they're brown and they're in the parking lot of Home Depot. That's not enough. ICE guidance for immigration officers likewise describes investigative stops supported by reasonable suspicion as one of the principal levels of encounters that agents initiate in enforcing the immigration laws. True. So why not have it? I mean, why can't they use reasonable suspicion? So, I'm confused. Immigration officers receive training on what reasonable suspicion entails and are taught to form reasonable suspicion based on the totality of the circumstances rather than any particular facts or considerations in isolation. Allegedly. That'd be great if that was actually happening. Here's our proceedings below. So, we are talking about the Los Angeles detain B16? We just talked about that. So I'm going to skip through. Here going forward because I want to see the escalation. Oh, yeah. Always met at the sanctuary city. All right. Well, let's take this one from the top. We may not make it all the way through, but I think this may be more important in order to understand the context here. So, proceedings below. The Los Angeles area is one of the most important regions for immigration enforcement in the country. So now we have an idea of why they keep targeting California, right? According to estimates from Department of Homeland Security data, nearly 4 million illegal aliens are in California, and nearly 2 million are in the Central District of California. Los Angeles County alone has an estimated 951,000 illegal aliens as of 2019, by far the most of any country in the United States. About 75% of those illegal aliens hail from Mexico, El Salvador, and Guatemala. And we're citing the migrationpolicy.org data. Illegal aliens form a significant proportion of California's workforce and are especially highly concentrated in certain sectors, such as agriculture, construction, food services, and transportation. Again, citation to where he got that from. The Cube's Enforcement and Removal Operations Field Office for Los Angeles, whose jurisdiction is coextensive with the Central District of California, comprises over 290 law enforcement officers in six offices who are responsible for enforcing federal immigration laws in 7 California counties with a combined population of over 20 million people. And then we're putting this in in a declaration. So this is just basically an affidavit. Someone wrote something out and then filed it. Based on current estimates, illegal aliens comprise about 10% of the entire Central District population. Where's our citation? Thus, while the previous administration carried out some 26,000 immigration arrests in the Central District, those efforts did little to alter the broader dynamics of illegal aliens entering the country and heading for the Central District, especially given its proximity to the border with Mexico. So is this a point where we say, I thought Mr. Orange was going to have a wall built, so this didn't happen? And he did not. So I'm going to say it's Mr. Orange's fault, right? I just don't think the amount of wall that he built, that he ran on for election, was built. And so that's what happens. And I'm saying this sarcastically. All right. Sarcasm. Complicating federal efforts further, in December of 2024, the Los Angeles City Council enacted a sanctuary city ordinance. Now, we have multiple sanctuary city lawsuits where the government is suing certain cities. The ordinance restricting Los Angeles law enforcement and other personnel from cooperating with federal immigration enforcement or participating in such enforcement. citing the law here. For example, the law limits local officers' ability to inquire into or collect information about an individual's citizenship or immigration status, investigate, cite, arrest, hold, transfer, or detain any person for the purposes of immigration enforcement, or participate in immigration enforcement in any operation, joint operation, or joint task force involving any immigration agent. So I'd pause here and I would say, for our sanctuary city places, and it's not just here. Oh, JD's no, get out, JD. Revoking special status. Yeah, what I would have to say here is, where's the cop that's like, well, this sucks that I have to not do this stuff? Where's the cop who's got a problem with the sanctuary city? Because contrary to popular belief, there's a whole ton of crimes and various things that officers are doing like every day. And I mean, they're booked solid on tasks and things that they have to do for their job. And now they're saying, well, with this particular area, you don't have to do this stuff. So where's, again, the police officer that says, I'm being harmed because when I go out and do a million things with almost like low pay and risk my life every day, but I'm upset because I can't do one more huge task. You know what I'm saying, everybody? Are you following me on that one? This drives me bonkers too. So who's complaining? Who is complaining? Right? Because I'm not seeing it. I'm not seeing the cops coming in and being like, oh my gosh, the only reason I became a cop is so that I could do this stuff and you took that away from me. Blah, 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 blah. No, you don't hear that. So, soapbox, everybody. All right. In early June, the Cubes and U.S. Customs and Border Protection commenced efforts to intensify immigration enforcement in Los Angeles. Large crowds of protesters responded by throwing concrete chunks, bottles of liquid, and other objects at federal officers, and launching mortar-style fireworks with multiple explosions at them. Protesters also heavily vandalized a federal building. Well, that's not okay. And I hope all of those people were arrested and charged appropriately. So there's that. The president deployed the National Guard to protect federal officers performing their duties. I'm not sure. I'm not sure about that one. I'm not sure. Despite these challenging conditions, from June 1st to mid-July, Arrow processed approximately 2,805 immigration arrests and numerous criminal arrests in the Los Angeles area, according to this person who signed an affidavit situation, all right? The mayor of Los Angeles responded by describing the Cube's enforcement activities as a reign of terror. I can't say that name. Right, so we're quoting here. Quoting. This case began on June 20th when 3 illegal aliens who were arrested in the Los Angeles area filed a habeas corpus action in the United States District Court for the Central District of California, seeking their release from immigration detention. These 3 individual respondents work as day laborers. They were arrested in Pasadena on June 18th in connection with a targeted enforcement action at a particular location, a donut shop. Oh, that's just sad now. Oh my goodness. Where past surveillance and intelligence had confirmed that the target or individuals associated with him were observed to have recruited illegal aliens to work on landscaping jobs. Again, coming from this declaration from this person here. Right. It could have very well been a U.S. citizen. On July 2nd, respondents filed an amended class action complaint, adding 2 U.S. citizen individual plaintiffs and 4 organizational plaintiffs, plus several federal officials as defendants. Respondents also filed an ex parte application for a temporary restraining order on July 3rd. Respondents' filings vastly expanded the scope of the suit to challenge the government's immigration enforcement operations across the Los Angeles area. As relevant here, respondents allege that federal immigration officers have adopted a policy and practice of conducting immigration operations in violation of their obligation to stop individuals in public only if there's reasonable suspicion. Respondents in particular objected that Cube agents were targeting certain types of businesses, like car washes, which past experiences have demonstrated are likely to employ illegal targeting certain types of businesses, like car washes, which past experiences have demonstrated are likely to employ illegal aliens. Respondents also complained that agents have conducted indiscriminate immigration operations, flooding street corners, bus stops, parking lots, agricultural sites, day laborer corners, and other places. The district court gave the government 2 business days to respond to the TRO application and held a hearing on July 10th. The next day, oh, hello, so unique. The next day, July 11th, the district court granted respondents' requested TRO and enjoined federal agents from conducting any detentive stops anywhere within the district without reasonable suspicion. That's the law, all right? So let's just highlight this, all right? They're mad because the district court said you may only detain people if you follow what the law says about detaining the people. So and he's mad about it. Like, are you freaking kidding me with that? You kidding me? This is crazy. The court specified that the prohibition means agents cannot rely solely on an apparent race or ethnicity, use of Spanish or accented English, presence at a particular location or type of work, either alone or in combination, as grounds for reasonable suspicion. The court acknowledged that there was no evidence of any official policy authorizing stops solely on those bases, but inferred from anecdotal evidence that immigration officers were engaged in a practice of stops based solely on those factors. So I'm going to pause again, and I'm going to say, this is where you can tell where we're at with, and I don't want to say intelligence, but willingness to do your job to the best of your ability, right? Because they're saying you can't use these 4 factors. These 4 factors alone aren't enough. Now, someone who is clever or just smart would say, all right, add a few more factors in, you dingleberries, right? And that's what our cops do all the time. That's what we do all the time. If we get questioned that we're, with our jurors, if we're choosing someone based off of, if we get questioned that we're, with our jurors, if we're choosing someone based off of, if they're a man or woman or man, woman, and the rest. Sorry, everybody. I mean, no offense. And, race and ethnicity. Like, we're not supposed to discriminate against that. And the only thing you can do then is when you're asked, like, hey, are you discriminating based off of race? Is you come in and you say, no. And what is it you're discriminating against? And if it was a juror, you would just say, no, this person seemed to not really be paying attention. So that's it. That's the issue here. You want to use these 4 factors, sour, then use the 4 factors. But, unlike everybody else, you don't get a free card to just do that. You actually got to use your brain and get yourself sorted out here. Yeah, I apologize. I'm not saying that right. It's a good question, Rasta Ranch. I usually say guys and gals and pals, and so that covers everybody. I don't want to miss anybody. We're inclusive here, all right? See you later, Duchess. Yeah, so you know what I'm saying. Everybody out there, you're not supposed to discriminate because of that, so it's important. As to standing, the court reasoned that respondents have standing for this putative class action based entirely on respondent Gavadia's allegations that federal agents had detained and questioned him based solely on his ethnicity. On the merits, the court concluded that respondents were likely to succeed on their claim that the 4 factors respondents had identified could not suffice to establish reasonable suspicion for a stop. Well, not alone. That's what the court said. not in and of themselves. The court added that insofar as agents relied on other factors, such as suspects' flight from federal officers, you can't bring that in. That's not allowed to be used either. The government does not show that they support reasonable suspicion. As to scope of relief, the court held that respondents were irreparably harmed by the prospect of future detentive stops and concluded that to provide complete relief, to the named respondents, the court must enjoin the conduct of all law enforcement engagement in immigration enforcement throughout the entire Central District of California. What is your opinion of the videos of these arrests? How should someone act when accosted by ICE? It's a good question, and I think it's a question for broaden it, make it broader. Any law enforcement comes at you like that. What are you supposed to do, right? So the cubes are out there presenting themselves as like this law enforcement, even though they really don't have the same training and level that our law enforcement has, but they're behaving that way. And so if you're in a sticky situation involving them, then you need to respond the way that you would with any other law enforcement. And you got to pick your road, right? Are you going to fight about it and wind up on the ground? Or are you going to say fine and fight it out in courts later? Or are you just going to be like, well, this isn't good, and try to talk your way out of it? That is normal in law enforcement. That's the thing, isn't it? Thinking about corporate law. Ooh, well, there's some people out there doing the corporate law. That's good stuff for them. But yeah, my emphasis, I cannot overemphasize this. I do not, first of all, truly understand the struggle of the non-citizens in this situation. I do not understand that. I do in a way that I think is sufficient, because I don't have a lot of that where I'm located in this country. That's not really something that is a huge piece. I mean, there are some, but there are some cubes around, but not a lot. But when we're talking about the aggression level of cops, it's like, you gotta be careful, because they have qualified immunity and they have the authority. And 1 minute, and you're talking about arrests, I saw an arrest where the copper was like, all right, name, blah, 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 blah. And the defendant was like, I don't want to tell you anything. And the copper's like, do it. I said, do it. And then the guy's like, I'm not going to do it. So this very calm sounding officer. And then the officer's like, get out of your vehicle, please. We need to talk. And then the guy was like, I'm not going to. The same kind of caliber as before. And then boom, that cop explodes. And then harm is on its way, and protected harm. So it's really, it's a sad situation, and interesting how quickly you can click from one to the other. They are both the good cop and the bad cop at the same time. Right. Immigrants are a huge part of the community in a rural place. Well, and I think that's fantastic. That's really fantastic. I am definitely, anytime I go out into the world outside of my little home in the sticks, I'm just always like, I can exhale. I'm like, all right, there's other people out here. It was guys in masks without uniforms. Right, and that was an issue. Should not have qualified immunity. That's, a lot of people argue about that. A lot of people say, good and bad with having that kind of immunity. What I will say, though, is that kind of immunity is very, it has to be very carefully used, because if there is a violation of civil rights, then that immunity will not protect you. Yeah, have a good one. So back into it here. The district court accordingly enjoined the government from conducting detentive stops in the district unless the agent or officer has a reasonable suspicion that person to be stopped is within the United States in violation of the U.S. immigration law. Again, this is just basic con law 101. The order further provides that applicants, except as permitted by law, may not rely solely on the following 4 factors alone or in combination to form reasonable suspicion for a detentive stop. And this isn't that unusual, everyone, for the court to come out and say, you can use this, but not by itself. The courts do that all the time. They'll say, well, yes, it's fine, but you can't use one particular piece. And I think I've gone through this before. Like if you have a conspiracy case, So like, well, I suppose we could toss in the DC RICO case. Oh, it's not a pure RICO case. So for Mr. Orange in the DC case, there were multiple people involved, right? So it was him and then multiple others. And there's this conspiracy factor involved. They had not been charged, only he had been charged. And people are like, why aren't they charged yet? And I think one of the most important things to remember is if you're in a conspiracy with other people, this is legal education, not legal advice, but if you are conspiring with other people, they can testify against you in court, right? And that's fine. But that cannot be your only evidence. You can't just bring in those 5, 6 other people to testify that they were in the conspiracy with you. You have to have more stuff. You have to have more. And so when they're saying you can't solely rely on these 4 factors, that's, normal. That happens all the time. And so they're asking the Supreme Court then to determine whether or not these 4 factors are enough in some kind of combination or, a couple with extra stuff. That's what the question's going to be in front of the court. Right. So Georgia was a RICO and DC could have been a RICO, but it was pled more as a conspiracy. Yeah, and I think that it was charged properly. So it was like one with a RICO, one without, but we had conspiracy in all of them. Right, so the point is, it's not like this is something that's brand new and special just for these people here that we're talking about, these people being the cubes. We're talking about lots of other things where they will put limits on it. They all should be RICO. Well, sometimes you got to kind of, pick your battles. And if you're RICO, like Georgia's RICO is so incredible. I think that's why Georgia was like, we're not even going to play around. We're just going to charge it up as a RICO. It was just, because that's one of the things they do in Georgia. So that's well known and they have success with it. Meanwhile, Jack Smith in DC is like, man, let's hit them with the biggest violation of all, which is interference with citizens' right to vote. I think he did pretty good. How long does it take to prepare for the LSAT? Good question. Everybody prepares a little bit differently. The one thing I would say is don't get bogged down in the minutia. Sit down, take your time to test, and do it once a day because you should see your score going up higher. And on your 5th practice test, you're going to see the kind of score you're probably going to get. So that's what I would say. Just make sure you do the practice test because it's not about the content. It's about the stress, the anxiety, and being able to push through those in order to answer enough of the questions correctly. That's my advice. Hey, Ava, I understand. Don't mute Ava. Don't mute her, all right? So Ava, let me just remind you that Mr. Orange is much more pleasant than a lot of the other names that he himself has used to describe people. All right. Now, he's the president, yes, but that doesn't mean that I can't call him Mr. Orange or Mr. Poopy Pants. I can call him whatever the H I want. So if you don't like it, I would recommend just go in another place, okay? All right, because Mr. Orange is the only one I can say without getting dinged in the algorithm, all right? Maybe we should switch to Poopy Pants. All right. All right, let's ask the chat. Chat, which one should we use? Which one should we use, Mr. Orange or Poopy Pants? I'm just curious. Call him C447. Oh my goodness. That's right. Okay, bye-bye. Poopy Pants. All right. Either Mr. Orange, Mr. Tangerine. Oh my gosh, Cheeto. Well, I had Cheeto. I had to put that in my words that had to be censored. Mega Mussolini. Triple P. Oh my goodness. Either's fine. All right. Agent Orange. Oh my gosh. For the respect of the office. Well, right. Come on. We don't. That's what Hawk calls him. Oh my goodness gracious. Hawk's got some of the best names. And so does Wiseacre. Oh my gosh. Those two together. It's like, what? Oh, oh my goodness. Ooh, tangerine. That's funny. All right. I think I have dealt with that in the best way. Mr. John did. Oh my goodness. Oh my gosh. That's so funny. Oh my goodness. No hate to people with the liver problems, but that's funny. Oh my goodness gracious. The alleged president. Oh my gosh. First felon of the United States. Y'all are hilarious. You know that, right? Mr. Bouquet calls. Oh my goodness. Oh, I can't. I got it. Oh my gosh, that's the funniest ever. All right. I gotta calm myself down. Be professional. Mm-hmm. Okay. Here we go. Oh my gosh. Like my side's hurting. Oh my gosh. All right. Here we go. Back to business. Here. Oh my goodness gracious. All right. 4 factors. Oh goodness. All right. Here we go. So, apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, bus stop, car wash, tow yard, day laborer pickup site, agricultural site, and the type of work one does. So these are the 4 pieces that cannot be used just alone. Tangerine nightmare. Oh my goodness. Oh my gosh, everybody. This timeline. I'm not sure about this timeline. The district court denied applicant's motion for a stay of the order pending appeal. It's scheduled a hearing on whether to issue a preliminary injunction for September 24th, meaning the court's order will remain in effect for the foreseeable future. The Court of Appeals largely declined to stay the district court's injunction pending appeal. The court only stayed one provision of the injunction authorizing reliance on the 4 factors as permitted by law, which the court considered vague. The court acknowledged the lack of evidence of an official policy of making stops based on the 4 factors and without reasonable suspicion, but shared the district court's view that officers were routinely doing so by citing, for instance, public statements by the CBP official, generally referring to potential further enforcement operations in Los Angeles. All right, so I'm going to skip through. Oh my gosh, let's skip to the next section here. All right, here's our argument, such that it is, everyone. Argument. Under Rule 23 of the Rules of this Court in the All Writs Act, the court may stay a preliminary injunction entered by a federal district court. And that's true. That's actually true. To obtain such relief, an applicant must show a likelihood of success on the merits, a reasonable probability of obtaining certiorari, and the likelihood of irreparable harm. The close cases, the court will balance the equities and weigh the relative harms. Those factors strongly support a stay here. So first we have the government's likely to succeed on the merits. So the district court upended immigration enforcement efforts throughout the entire Central District of California, a vast area encompassing some 20 million people and an estimated 2 million illegal aliens by categorically enjoining immigration officers for conducting investigative stops that rest solely on the combination of these 4 factors, i.e. a suspect's apparent race or ethnicity, whether he speaks Spanish or accented English, whether he's at a location where illegal aliens are known to gather, and whether his job is prevalent among illegal aliens because of the lack of documentation required. That's just so, just pointing out how, this is how generalizing can get you into trouble here. That legally flawed injunction warrants this court's review on several grounds. Again, they're asking the Supreme Court. First, respondents, 5 individuals and 4 organizations, lack Article 3 standing to obtain an injunction barring investigative stops based on the prohibited factors because no respondent faces any immediate risk of being subjected to such a stop. I don't think that's correct, actually. I think you're making the argument for the other side. Second, the district court's order contravenes bedrock Fourth Amendment principles by imposing categorical rules that artificially limit inferences of reasonable suspicion, and by wrongly holding that the four factors, even in combination, can never amount to reasonable suspicion. Finally, the scope of the injunction is plainly unlawful. By issuing an injunction encompassing anyone within the Central District of California, an injunction encompassing potential millions of non-parties. The court defied Trump v. Casa, which is the case that was just done here. So next we've got respondents' lack of standing to seek injunctive relief, restricting investigative stops. So we've kind of heard that drum quite a bit. Moving right along here. I've got the Muppets song in my head still. I mean, you play the Muppets moving right along for like a 12-hour drive, and I mean that's what true torture is. Right. I don't mean that. I apologize. Number 2, district court grossly misapplied the Fourth Amendment. This is one thing when you've got judges down here in the district courts that work, this is their job. I mean, every day in and day out, they're working these kinds of cases. And this judge is like, well, the Fourth Amendment, blah, 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 blah. I mean, she's in the trenches. So this argument itself is what the Supreme Court would have to take a look at. And they are not giving definitive answers to anything. So I doubt they're going to come in and say, well, yeah, the Fourth Amendment was misapplied. They could, but then that would change the entire doctrine. So they could, but let's hope they don't. Fast forwarding here as we go through. Right, fast forward. Oh, here we go. Subsection 3. Central district-wide injunction vastly exceeds the district's court's equitable powers. So that was one thing too in the Casa case. They're saying like nationwide is not allowed, but if you're just in a specific district, that was not assessed. That was not determined in the Casa case. So that piece may need to be relitigated. And we're gonna fast forward again here. All right. The remaining state factors support relief. So again, they're coming in and saying the rest of the winter factors are not present. So this court would likely grant certiorari under their own ideas. The district court's order inflicts irreparable harm on the government. I'm not sure. This Enkin and Holder case has been what they are holding on to in all of these cases. I'll take you through that case at some point, but I'm not sure. I mean, they're definitely kicking Enkin around quite a bit recently, but I'm not sure that this has risen to that level yet. Maybe. The balance of equities weighs in the government's favor. Again, we're talking about these winter factors. Here, an administrative stay is warranted. Let's read that. Let's this will be our conclusion here, everyone, to figure out exactly what we're dealing. BC, I see you. Oh my goodness. Come on. Oh my gosh. All right, I can't laugh anymore. I'm getting a stitch in my side. All right. C. An administrative stay is warranted. The Solicitor General, so his criminal defense attorney in the Stormy Daniels case, also respectfully requests that this court grant an administrative stay on the district court's July 11th order while the court considers this application. Every day the district court's order remains in effect, law enforcement officers throughout the most populous district in the country are laboring under the threat of judicial contempt. Daunted by the prospect that their good faith efforts, that's not true, efforts to enforce federal law will be retrospectively deemed to violate a far-reaching, unlawful, and ill-defined injunction. None of that's true. In these circumstances, an administrative stay is warranted while this court assesses the government's entitlement to a stay. And then in our conclusion, the court should stay the district court's July 11th order enjoining applicants from conducting detentive investigative stops in the Central District of California based on 4 enumerated reasonable suspicion factors. In addition, the Solicitor General, so the defense attorney in the Stormy Daniels criminal case, everyone, lest we forget, the Solicitor General respectfully requests an immediate administrative stay on the district court's order pending the court's consideration of this application. Respectfully submitted, the defense attorney in the Stormy Daniels case. All right. Right. What? Do I get that mixed up every time? I get the Sawyer and the other fella. They're pretty much interchangeable in my opinion. I would have expected he'd have a better argument here. Well, I don't know. Can we see those nails, please? Oh, of course, of course. I don't know. To me, they all are part of the same creature. Here we go. Where are both of these individuals having Frenchy names? Oh, that's a good point. Yeah, Beauvais. And then we have the other fella. There we go. Thank you so much, everybody. These are my California nails. California nails. All right. So, right. So we've got Sauer. Let's just remind me of this. We've got Sauer. He's the one that did the SEAL Team 6, right? So if he's like, well, if the SEAL Team 6 needs to do it, then they're going to do it. And then we have Beauvais, who doesn't know how to do trial questions. So he was in some of the trials. And then that third guy that looks all grumpy all the time. Right? Right. Turnus may as well be Mr. Smith from the Matrix. I think that's true. It's a lot. Blanche. Right. Mr. Blanche. Right. So, and Mr. Blanche was the one that was like getting into the details of the Stormy Daniels situation. So we'll keep that in mind. Which one of them? Right. So we'll keep that in mind. I feel like they're all interchangeable. So they all agreed to work these cases, and they all agreed to go down that road. Mr. Grumpy Pants. That's a good one. All right. So with that, now that we've set out the attorney situation, let's talk. What do we think? You think the U.S. Supreme Court is going to take this application? Or are they going to deny it? What are our thoughts? Right. So yeah, sorry, BC. Yeah. So in the Colorado case, the Anderson case, right, that has to do with him being put on the ballot. But if you go back into the immunity case, this is the presidential immunity case situation that's being argued. And this also had to make it through all of the different stops, right? Right. So there was a lot of action going on there. We'd have to brief it. Oh my gosh, exactly. We'd have to brief it. Hope they denied, but either way, you never know. True. And it's hard to predict anymore. It's really hard to predict. We have a Court of Appeals and a district court that are like, let's stay. Again, the only thing for a stay is we're pausing this while we finish the litigation until the question is answered. We're not pausing the whole trial. We're just pausing this until it's done. So I don't know. Thompson and Alito will say yes. Roberts will push to reject it. I think that's fair. Should be removed. Right, and they tried. Man, Colorado tried so hard to get him off of the ballot. Like, I just am overwhelmed without hearing anything. Now, that's possible too, Willie B. Absolutely possible. I have I'm going to be starting a new series where I have which federal judges have been impeached and, found guilty or convicted by the Senate. And there's quite a few. And so far, I think there's like 15 of them. And 2 of them were because they were intoxicated on the bench. So, here we are like, well, you're not giving people the proper information or you're withholding information. And meanwhile, back in the day, it was like, dude, stop drinking. I thought that was funny. Yeah, then he sent it to the, gosh, I just can't even. I just can't even with this guy. I can't. Yeah, there's some interesting ones out there for sure. So I am kicking that series out. That should be pretty fun. Right. All right, everybody. Well, with that, my friends, now that we've cleared everything up, I'm going to have to put little pictures. That's what I need to do. I need to put a little picture together of all of the attorneys so that we know. Because Blanche, he's like number 2. He's number 2 out of the DOJ, right? And then Bove is about to be sworn in as a federal judge. And then the Sawyer fella is the Solicitor General arguing on behalf of the United States, right? I know, right? Oh, yes, of course. All right, thanks, Ruby. All right, well, with that, my friends, I will be back again very soon. We've got a lot of stuff to go over still. I have the next one I've been thinking about, everyone, is we've got Congress suing the department, suing the Cubes. So this was just filed a couple of days ago, and so I think I'll probably do this one next. It's got the most pieces to it. So with that, have a wonderful night, everybody. I appreciate you all coming by and hanging out with me. Take care of yourselves, and I'll see you all again very soon.